The right to marry does not include right to compel the state to create a new definition of marriage. Parliament can do, but it's not an absolute right. Now, my lord, kindly consider when your lord, therefore, my lord, again at the cost of repetition, my appeal to your lordship is, my lord, that rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord, if need be, I'll assist your lordship with that law. Question, my lord, before I come to the real question, my lord. As I started, my lords, not only as a law officer, but even as an advocate, as an officer of the court, or even as a citizen, your lordships are dealing with a very, very complex subject, having a very, very profound social impact. I would earnestly reiterate my request, my lord, if your lordships can consider leaving all these questions to Parliament for the reason, my lords, that your lordships have read right to choose the sexual orientation in Nautet Johar, and there is no dispute about it. Your lordships have said that based on one's sexual orientation, there cannot be any discrimination. There cannot be any dispute about it. Right of personal autonomy, namely right of choice, is also recognized by your lordships in Nautet. Therefore, my lord, the question is, Lord, now what is the prayer before your lordship is right to get the socio-legal recognition of marriage. Lord, the question so far argued was what constitutes marriage and between whom marriage can be constituted. The real question is who would take a call as to what constitutes marriage between a particular class of people. Well, that takes me to my first respectful submission, and my lords were very kind enough to say.
What did you say? Who would take the call on?
What constitutes marriage and between whom? Therefore, my lords, when I made the first request, my lords were very kind enough to say that let us have the canvas, let us have a broad conspectus of what their arguments are, and thereafter we'll take a call. Your lordships were pleased not to reject that, my lords. So, my lord, I am reiterating that request. It's my appeal to your lordships, my lord. But there are several ramifications, not only, my lord, on the society, several ramifications, unintended ramifications on other statutes, which would need, Lord, a debate in the society, debate in various state legislatures, debate in civil society groups. So, my lord, at the outset, my lord, I say, my lord, your lordships can consider saving the rest of the exercise if your lordships, my lord, are convinced that this has to be preceded by some debate, particularly when the debates would take place in a forum where there would be assistance of national views, views of experts, views of impacts, views of effects it will have, and what are the implications on several laws. Lord, I have provided the list of about 160 sections from various provisions of law, other than, my lord, Special Marriage Act or law relating to marriage, where it cannot be reconciled with what is sought to be prayed, my lord. Your lordships have the legislative policy so far. The legislative policy has always been in all the laws, my lord, which your lordships have come across on several occasions, has been to recognize conventional man and conventional woman. I understand difference between gender and sex, sexuality and gender, etc. We are not going into it. But all laws, my lord, whether it is criminal law, civil law, any other law, law giving protection to women, etc., they define the man and woman in the conventional sense. When this question is being debated before your lordships for the first time, I'm posing a question to myself, and my lord, based on that, appealing to your lordships, should it not go first to the parliament or the state legislature? No one is sitting in on value judgment whether this should be, this is good, this is bad, this should be done, this should not be done. There is no stigma attached. My lord, the parliament has accepted their right of choice, their right of sexual preference, their right of autonomy, and that right of privacy.
Right of choice.
Autonomy, sexual autonomy in terms of sexual preference, and the privacy, that is right of intimate relationships, which your lordship said, my lord, something happening between two consenting adults in privacy. Why I say, my lord, that there is no stigma. The legislative policy is very clear now in the Transgender Act, where the term transgender is very widely defined to include, my lord, all shades and all spectrums of what we call LGBTQ plus. Transgender Act is the response of the Parliament, my lord, in view of Navtej Johar, my lord, and other judgments, my lord. There are specific provisions where discrimination is prohibited and is criminalized. I'll take your lordships to the, my lord, scheme and architecture of the Transgender Act. There is no stigma. The limited question is whether right to marry can be prayed for as a social institution by way of a judicial adjudication before this honorable court. The right to marry does not include right to compel the state to create a new definition of marriage. Parliament can do, but it's not an absolute right. Now, my lord, kindly consider when your therefore, my lord, again at the cost of repetition, my appeal to your lordship is, my lord, that rather than, my lord, taking this matter any further, if your lordships are convinced that this is possibly a subject which may better, my lord, be left to the choice of the parliament, which is the law, my lord, if need be, I'll assist your lordship with that law. And the subject is such that your lordships may not be in a position to conceive of variety of situations which may arise and which will have to be taken care of. Lord, mere declaration that they have a right would be, my lord, begging the question. If they have a right, how the rights would be regulated? How variety of problems will be solved? And I'll give examples, my lord, which only parliament can take care of. Now, my lord, kindly consider, my lord, pre-56, marriages used to take place between heterosexual persons, my lord, conventional man, conventional woman. There was no recognition except societal acceptance. Correct, Manoj? Once it gained societal acceptance, in Hindus at least, it came to be codified in 1956 by way of a Hindu Marriage Act. For other religions, by and large, it remains uncodified. Marriage between heterosexual, same religion persons. I am on the concept of marriage, the social status which it gets. Now, my lord, the moment any right which was pre existing, even without recognition by law, is recognized, it is also regulated. And then there is no absolute right to marry, even today, between heterosexual couples. And why I say this? A man has to be 21 years and a woman has to be 18 years, meaning thereby the law prescribes when to marry. The autonomy goes. Bigamy is prohibited. So law prescribes how many times you can marry simultaneously till your wife is or husband is alive. There are prohibitions regarding degrees of prohibited relationships, meaning thereby law regulates whom not to marry. Once the law recognizes this socio-legal institution as a marriage, you just can't walk out of that institution. Law regulates even that, on what grounds you can have judicial separation and on what ground you can have divorce. So how to separate is also a legislatively regulated provision.